Today on Legalese, we are discussing the viral criticisms of Justice Ketanji Brown Jackson coming from Republicans who are claiming she doesn't understand the Constitution. So stick around because this episode, this is going to get spicy as fuck. Hey, greetings, everybody, and welcome back once again to Legalese. Now, as always, I'm your host, Bob, and I want to thank you all so much for joining me here today. And if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Real quick, want to remind you guys, if you want to find out more about the show, you should go check out our homepage over at legalespodcast.com. And if you want to stay up to date with my new content, because I don't just do videos on YouTube, I also write articles on Substack. Substack also just so happens to be where I do the show notes for these shows. But anyways, so I also post an audio-only version to Spotify. I post to alternative platforms as well. And so if you want to get updates whenever I put out any new content, or if you just want to get curated updates when I put out particular types of content, either way, all you have to do is go head over to legaleshow.com, and there you can sign up for our newsletter and get notifications sent right to you. All right, well, this should be an interesting show. It has been a long time since we have had a discussion of the Constitution and the law get dragged so far into the culture war and get me so agitated that I just had to drop everything else that I was doing and do an episode on this topic instead. I think the last time that happened was perhaps the Brunson v. Adams case well over a year ago. And in fact, I used to do these types of videos a lot more often, and I'd be lying if I said I didn't occasionally miss doing these just a little bit. But anyways, today we are going to be talking about an argument that Justice Ketanji Brown Jackson made during the oral arguments in Murthy v. Missouri on Monday, where she talked about how the preliminary injunction from the Fifth Circuit, or at least she was talking about how ostensibly that injunction will, as conservatives will say, hamstring the government, which brought out all manner of conservatives who were champing at the bit to point to this and say, look, it's just like we told you, the left hates the Constitution. And in a way, I'm very glad they did this, because this is providing me the perfect opportunity to sound off on a topic that I have really wanted to let loose on, really ever since my recent series of videos on the net choice cases that came before the Supreme Court a couple weeks ago. And that is how all the conservatives who have been using this recent comment by Justice Jackson to talk about how the left hates the Constitution and Justice Jackson doesn't understand the Constitution have provided the ideal opportunity to explain why it is those conservatives who don't understand the Constitution. Now, usually in my videos, I make a concerted effort to jump right into the substantive discussion of the topic without much filler. But because of the nature of this video, I do feel that there are a number of caveats that I really need to kind of take care of right at the front of this video, because past evidence has shown that this stitch in time will absolutely save nine, especially when pissed off conservatives who don't follow my channel and know nothing about me stumble on this video and don't bother to actually listen to my substantive points before they write me off as some kind of Constitution hating, free speech hating, America hating commie libtard. So bear with me, I will try to get through this as quick as I can. So first of all, I want to clarify something. I titled this video A Conservative Defense of Ketanji Brown Jackson. And while that is technically an accurate statement, is probably not accurate in the way most people are going to read it. I am not a Republican, nor am I a conservative. I am a constitutional originalist, and that is all I mean when I say conservative, which really just makes me a conservative in the same sense that a Clarence Thomas or a Neil Gorsuch is a conservative, which is something entirely different from being a political conservative in the sense that a Jim Jordan or the anchors over at Fox News, who I will be criticizing, are. And I want to make this point clear. This term does not apply to me in any sense. nor will I be making a politically conservative argument. In fact, I hesitate to even bring up politics at all because this isn't going to be in any sense a political discussion. Because the fact is that trying to make what was a discussion about the law a political discussion is precisely what caused people to misunderstand Justice Jackson in the first place and to drag this very serious and important argument around government mass surveillance and the ability of the First Amendment to protect people from both direct and indirect mass censorship by the government has been dragged into this very stupid and vapid arena of the culture war, which is a term that frankly makes me throw up in my mouth a little bit every time I even say it. Now, that said, while I would rather not bring politics up at all, I think it is perhaps helpful to point out from the jump that I am neither a Republican nor a Democrat. I am not a political conservative. I am not a progressive. I'm a libertarian. As such, for people who will insist on making this a political discussion, and there will be those people, I want to be clear that in that sense, I don't have a dog in this fight. That said, uh, the reason I use the term conservative in the title is because I am, as a constitutional originalist, you could say something of a legal conservative in that I do believe the meaning of the Constitution was fixed at the time of its adoption, and it is fixed according to the original understanding of the framers and ratifiers who gave that document legal force, and that modern constitutional interpretation and construction should be bound by that fixed meaning. Now, I bring this up because, of course, this also means I am not a legal liberal or progressive the way a Justice Jackson would be, or the other liberals on the court. Now, because Justice Jackson is a progressive originalist, I do tend to think she gets things right more often than her two living constitutionalist colleagues on the court, Justice Elena Kagan and Justice Sonia Sotomayor. But where I tend to agree with Justice Jackson as a matter of jurisprudence really tends to be the exception and not the rule. So please don't mistake my argument here as some ideological liberal blindly defending Justice Jackson because I'm part of some liberal hive mind. And in fact, and you'll see this if you watch my other videos on the whole of the Murthy v. Missouri case, is that I actually overall completely disagree with the ultimate conclusions that Justice Jackson draws in the Murthy case as a whole. But this isn't about that. This is about a very particular statement she made that people are either ignorantly misunderstanding or maliciously misrepresenting. So, what you need to understand is that the problem with the criticism from the Jim Jordans and his ilk against Justice Jackson is that they are factually inaccurate characterizations of what she actually said. This video is not a defense of her opinion of the First Amendment. It is a video to prove that her comment was in no way an expression of her opinion of the First Amendment. And this becomes clear if you merely listen to her full discussion in context, rather than the context devoid soundbite that has been clipped to make her look bad through a mix of dishonesty, bias, and massive ignorance. She is making an argument about the nature of First Amendment jurisprudence and the court's precedent and how those things shape and interpret the First Amendment over time, as well as the legal doctrines and tests that they have come up with as matters of constitutional construction over the years to distinguish between what is constitutional and what is unconstitutional for the purposes of First Amendment jurisprudence. And despite what the vast majority of Americans think, the definition of constitutional is not everything I would personally like the government to do, and unconstitutional is not defined as anything I personally think the government should not do. So she is making a legal, factual, and historical claim about the nature of the First Amendment as a matter of constitutional law, and her understanding of the First Amendment as it is grounded here in constitutional law is correct. And I think that pretty much covers the bases that I needed to cover off the top. So let's get down to business here and look at exactly what Justice Jackson said, what her conservative critics are saying she said, and why Justice Jackson is not wrong and her critics are. So, first, I want to try and present this unfolding mess as it has been appearing in the news and across social media. So, I want to start with the clickbait soundbite of Justice Jackson that has been going around the internet.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods.
Now, what you just saw, is the extent of the context that the conservatives think is required to make these sorts of scathing indictments about why Justice Jackson supposedly both hates and doesn't understand the Constitution. This includes things such as a tweet from Jim Jordan, where he is talking about that the First Amendment hamstrings the government because that's what it's supposed to do. He says that this was literally one of the craziest things he has ever seen a Supreme Court justice say. It makes no sense to him. He says that this is frightening, and if she really believes that, we are headed in a scary direction. And actually, if any of that were true, I would entirely agree. If that is what she actually said and what she actually believed, that would be a damning indictment. Fortunately, Jim Jordan is a hypocritical idiot, and he couldn't be more wrong. Now, of course, Fox News had to jump in, and they would make the claim that what Justice Jackson is saying is that she doesn't like the fact that the First Amendment makes it difficult for the government to censor people. And again, if this is what she had actually said, I would be right there out next to these idiots with a pitchfork and an effigy of Justice Jackson. That would be a horrific thing to hear a Supreme Court justice say. Fortunately, as I have said, it's not even close to the truth. However, what really has me so hot and bothered about all of this is not that conservatives are getting this wrong. Being wrong is a human condition and a forgivable error. It's because what conservatives are doing here is attempting to dishonestly and unfairly impugn and delegitimize the Supreme Court in the eyes of the American people. Now, what's so ironic and disgusting is that they are doing this in the very same way that the left is trying to do that. When they talk about the court being an extremist court of far-right ideologues who are so corrupt and so dangerous, we need to make the court a political body by packing the court. And of course, once Fox News gave their official take, we saw all the other conservative rags come out and pair it with virtually identical headlines. So here we have the Federalist and the Washington Examiner both running with headlines that basically say Justice Jackson is complaining that the First Amendment is hamstringing the government's efforts to censor people. And again, I want to be clear. If this is what she actually said, I would be enraged too. Fortunately, whoever wrote these articles are idiots as well. Then, there is a truly ignorant tweet from Jim Jordan. So here he claims that this whole thing is indicative of the fact that the left wants less speech, not more. And to the extent he is talking about the political left, he's not wrong there. The political left certainly has a current running through it of people who seem to be contemptuous of the First Amendment. I mean, in fact, that's exactly what this Murthy v. Missouri case shows. Now, that's not all of them. There are some good progressives out there on free speech. I hesitate to name any of them because I had named some of them, and in the meantime, I've actually found them also condemning Justice Jackson on this same misunderstanding. So, in fact, you can see that the tweet that Jim Jordan is retweeting there is from System Update. That is Glenn Greenwald's show. Now, I love Glenn Greenwald, and I had made a list of good progressives on the left who really are fighting the good fight for true freedom of speech. And then I realize that one of the tweets that I am about to present in my video shows him spreading the same misinformation about Justice Jackson as well. And so, yeah, I don't even know what to say about that, really. So, really, I guess what I will say here, though, is that this whole thing is that I mean, as far as the left uh, being contemptuous of free speech, I mean, certainly the COVID-19 pandemic, the Twitter files, the factual findings in Missouri v. Biden, these all show the left as an institution is now contemptuous of free speech. Even the ACLU, a once truly heroic organization that I absolutely idealized, they recently came out and said that their longstanding aim of defending civil liberties on a content neutral basis seems to be in conflict with their new culture of pushing progressive values and causes, and as such, they are openly announcing that they can no longer be an organization concerned with the former if they want to be an organization dedicated to the latter. But the reason I say all that is because whatever the political left may think about the First Amendment is irrelevant here because Justice Jackson isn't making a political argument, nor is she even expressing her personal opinion about either the scope or the value of the First Amendment. She is making a legal argument fundamentally rooted in constitutional law. Now, at this point, I can virtually hear the people watching this saying, well, if she isn't saying what everyone is claiming she is saying, what is she saying? Well, to start with, why don't we actually take the time to listen to the full exchange between Justice Jackson and between the Missouri Attorney General who she was talking to during that portion of the arguments that has come into controversy.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is our position is not that the government can't interact with the platforms there. They can and they should in certain circumstances like that present such dangerous issues for society and especially young people. But the way they do that has to be in compliance with the First Amendment. And I think that means they can give them all the true information that the platform needs and ask to amplify that.
Right, but you're just saying that. I guess I thought when you say the way they do that is consistent with the First Amendment is that they have to show that they have a compelling interest to do what they're doing. In other words, you want us to take the line to be between compulsion and encouragement. And what we're looking at is the government can't compel, maybe they can encourage. I'm wondering whether that's not really the line. The line is, does the government, pursuant to the First Amendment, have a compelling interest in doing things that result in restricting the speech in this way? That test, I think, takes into account all of these different circumstances, that we don't really care as much about how much the government is compelling, or maybe we do, but in the context of tailoring and not as sort of a freestanding inquiry that's overlaid on all of this. Does that make sense?
It does, Your Honor, and I apologize for missing your guidance earlier. So the way I think about that is I've been discussing the standard, and I thought we've all been discussing the standard on the front end of the analysis, which is there a First Amendment violation? Is there an abridgment of speech? I guess I would conceptually think of strict scrutiny, narrow tailing, compelling interest as coming in at the back end to say, yes, maybe in the ordinary case, the government shouldn't have been permitted to undertake the kind of suppression of free speech that it did, but in this unique circumstance, it actually had a compelling interest, and it used narrowly tailored means to accomplish that interest. I mean, I think that's the fail-safe. If you're concerned with the breadth of our arguments, that's one fail-safe, which is no matter how broad the standard the court adopts, there's always going to be strict scrutiny at the end of the line to save the government in times where it desperately needs to do the things that you're outlining.
Thank you.
Thank you.
So really, the fact is that all Justice Jackson is actually saying here was that the government, of course, does not have the right to punish people criminally for engaging in the vast, vast majority of all speech. She was asking the Attorney General to what limit may the government have the right to persuade people without crossing that First Amendment threshold. Which is really, if you understand Murthy v. Missouri, the central question of the entire case. And the fact that so many people weren't even able to recognize that distinction is a truly damning statement about why this is a real reason we should be troubled about the direction of our country and where it is headed. The simple fact is anyone who only provided you the 6-second soundbite of Justice Jackson that I started showing you earlier in the video, or who does, as Jim Jordan does, in fact, not even show that, but merely copies and pastes a partial sentence out of context in a way that makes it clearly appear to say something that Justice Jackson clearly did not say, either did that because they haven't watched anything beyond the 6-second soundbite that's floating around out there, or they did listen to it in context and they chose to intentionally misrepresent Justice Jackson's statement. Either way, someone who presents you that kind of news, whether out of ignorance or maliciousness, is someone you should not trust. That is people like Jim Jordan. There is no conclusion that can be drawn from his many comments expressing his supposed outrage with Justice Jackson except to say that he either didn't bother to listen long enough to understand what she actually said, or he did and he still chose to willfully lie to hundreds of thousands of people who first picked up on this story from his tweet. My guess would be as the latter, though. The fact is Jim Jordan is actually very invested in this case. I can't imagine he wasn't paying careful enough attention to understand that he was engaging in a willful and malicious slander. Now, I can't know the man's precise motives or read his mind, so I can only speculate on whether this was ignorance or maliciousness on his part. I can't say for certain, but it can only be one of those two options, and either one should be roundly condemned. But back to the matter at hand. Even though the exchange I just played of her extended and in context remarks was about 3 minutes long, you don't have to listen through all of that to realize that the Jim Jordans out there are lying to you. You just need to read the next fucking sentence. Right after she makes that comment about the hamstringing, she follows up and says, this is a direct quote, I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, it's not going to get it done, end quote. Right there, she very clearly clarifies that the thing that she just said about hamstringing government was not a general criticism of the First Amendment. She was further clarifying a completely hypothetical question that she had asked a little earlier. So to understand her hamstringing comment, it is absolutely essential that we hear and understand the hypothetical question that she is even talking about to begin with. So I'm going to play that for you now.
That's Your
Can
Honor.
I give you a hypothetical?
Sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. This is obviously extremely terrible, and the public shouldn't tolerate this. Platforms, we see it's going on the platforms.
But they can't call the platforms and say, listen, we really think you should be taking this down because look at the problems that it's causing?
If it's protected speech, Your Honor, then I think we get closer. But, look, if you think that if that's clearly the way you're asking the question, I understand that the instinct that may not be a First Amendment issue. I guess what I fall back on, Your Honor, is that at least where the government itself, there is no emergency like this, there's nothing.
No, my hypothetical is there is an emergency. My hypothetical is that there is an emergency, and I guess I'm asking you, in that circumstance, can the government call the platforms and say, this information that you are putting up on your platform is creating a serious public health emergency. We are encouraging you to take it down.
I was with you right until that last comment, Your Honor. I think they absolutely can call and say, this is a problem, it's going rampant on your platforms. But the moment that the government tries to use its ability as the government and its stature as the government to pressure them to take it down, that is when you're interfering with third-party speech rights.
Well,
and remember,
Go ahead, finish
Your Honor, I was just going to say, even remember that the third party here is completely absent from the conversation. The third party whose speech is being targeted and ultimately censored is absent from this discussion.
Well, do you think that simply Justice Jackson's hypothetical ended by saying, we encourage you to take it down? Is that rise to the level of coercion that you think is problematic?
Your Honor, if the test is coercion and that's the test that this Court applies, I think I might have a harder case saying that's coercion. I think it's, by its definition, it's maybe easier addressed as a substantial encouragement case. But
So that hypothetical scenario I just played for you, the one about the new teen challenge on social media, her hypothetical is clearly contemplating persuasion only, not coercion. She could not have been any clearer about that. She asks, could the government try to persuade people not to do this challenge? Then she asks, could the government try to persuade social media companies not to host content promoting this challenge due to the harm that it is causing? Now, you are free to agree or disagree about the propriety of the government trying to persuade these platforms to remove content like that sort of teen challenge hypothetical she is presenting here. Now, in fact, the Attorney General, his response to that question was, quote, no, that's still protected speech even if it's dangerous, end quote. And that view offered by the Attorney General about the government's ability to persuade social media companies to remove such content may very well be the correct interpretation. But still, it's important to understand all she is doing here is asking a hypothetical question so she can better understand the argument the Attorney General is making about when he believes even voluntary persuasion crosses a line into a potential First Amendment violation. Isn't that precisely the kind of question a judge should be asking in a case where the parties to the case are asking the court to decide whether actual communication between the government and social media, in which the government strongly encouraged social media companies to remove content that they deemed to be harmful, was or was not a permissible form of government speech? Justice Jackson's comments here have to be just about the most benign and most appropriate question any judge could have possibly asked in a case like this if they were trying to reach a fair determination on the merits. So at this point, I want to I want to play the full clip for you of her full line of questioning. I want to play you both the proposed hypothetical, and then I want to cut right to uh, the second part where she makes her hamstringing comment. And so I want to play her entire conversation for you in context, in chronological order here. So this is how you would, if you had been listening to the entire trial like I had, this is how you would have heard this discussion happen. Now, the reason I saved this until the end is because to present it to you this way, I do have to clip out some sections of conversation that took place between Justice Jackson's questions. You see, this was during the seriatim portion of the hearing, where the ability to ask questions was a free-for-all among all the judges, so there were some interruptions and irrelevant conversations from other justices. So I didn't want to present it to you this way until you understood that what is obviously going to be an edited clip I'm playing for you here is edited specifically to fully include Justice Jackson's discussion and only her discussion, and removing the irrelevant lines of discussion and playing what she says in chronological order. So here we go.
An abridgment of speech, and
So I think that part of the reason why you might be running into all of these difficulties with respect to the different factual circumstances is because you're not focusing on the fact that there are times in which the government can, depending on the circumstances, encourage, perhaps even coerce, because they have a compelling interest in doing so. And so that's why I keep coming back to the actual underlying First Amendment issue, which we can isolate in this case and just talk about coercion. But I think that you have to admit that there are certain circumstances in which the government can provide information, encourage the platforms to take it down, tell them to take it down. I mean, what about the hypo of someone posting classified information? They say, it's my free speech right. I believe that I got access to this information and I want to post it. Are you suggesting that the government couldn't say to the platforms, we need to take that down?
No, Your Honor, because I think that would be a great example where strict scrutiny would cut in the government's favor.
All right. So what do we do then in a situation in which, I suppose in this case we're asking, the government's point is we didn't coerce, and I appreciate, the debate about that. But you just seem to suggest that as a blanket matter, the government doesn't have the ability to, encourage or require this kind of censorship. And I don't know that that's the case.
So, Your Honor, I guess this goes to the bully pulpit as well. As I understand that the bully pulpit has never been used to target the object of suppressing a third party's speech. You can use it to coerce behavior. You can use it to coerce companies to take certain actions. But when the government is identifying a specific viewpoint and specific content that it wishes to wholly eliminate from public discourse, that's, I think, when the First Amendment problem arises. And so I guess I'm struggling to find an example in the court's cases or in history where the court or anybody else has said the government, by virtue of being the government, can use its power to pressure its speech intermediaries to eliminate entire viewpoints and content from the public discourse. And I think, that's Your Honor.
Can I give you a hypothetical?
Sure.
Suppose someone started posting about a new teen challenge that involved teens jumping out of windows at increasing elevations. This is the challenge. And kids all over the country start doing this. There's an epidemic. Children are seriously injuring or even killing themselves in situations. Is it your view that the government authorities could not declare those circumstances a public emergency and encourage social media platforms to take down the information that is instigating this problem?
Your Honor, the government absolutely can use the pulpit to say publicly, here's what we recognize to be a public health issue, emergency. This obviously extremely terrible, and the public shouldn't tolerate this. The platforms, we see it's going on the platforms.
But they can't call the platforms and say, listen, we really think you should be taking this down because look at the problems that it's causing?
If it's protected speech, Your Honor, then I think we get closer. But, look, if you think if that's clearly the way you're asking the question, I understand that the instinct that may not be a First Amendment issue. I guess what I fall back on, Your Honor, is that at least where the government itself, there is no emergency like this. There's nothing.
No, my hypothetical is there is an emergency. My hypothetical is that there is an emergency, and I guess I'm asking you, in that circumstance, can the government call the platforms and say, this information that you are putting up on your platform is creating a serious public health emergency. We are encouraging you to take it down.
I was with you right until that last comment, Your Honor. I think they absolutely can call and say, this is a problem. It's going rampant on your platforms. But the moment that the government tries to use its ability as the government and its stature as the government to pressure them to take it down, that is when you're interfering with third-party speech rights.
Well,
and remember,
Go ahead, finish
Your Honor, I was just going to say, even remember that the third party here is completely absent from the conversation. The third party whose speech is being targeted and ultimately censored is absent from this discussion.
Well, you don't.
Thanks.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And, Your Honor, I understand that instinct, and I guess what I tell you is our position is not that the government can't interact with the platforms there. They can and they should in certain circumstances like that present such dangerous issues for society and especially young people. But the way they do that has to be in compliance with the First Amendment. And I think that means they can give them all the true information that the platform needs and ask to amplify that.
Right, but you're just saying that. I guess I thought when you say the way they do that is consistent with the First Amendment is that they have to show that they have a compelling interest to do what they're doing. In other words, you want us to take the line to be between compulsion and encouragement. And what we're looking at is the government can't compel, maybe they can encourage. I'm wondering whether that's not really the line. The line is, does the government, pursuant to the First Amendment, have a compelling interest in doing things that result in restricting the speech in this way? That test, I think, takes into account all of these different circumstances, that we don't really care as much about how much the government is compelling, or maybe we do, but in the context of tailoring and not as sort of a freestanding inquiry that's overlaid on all of this. Does that make sense?
It does, Your Honor, and I apologize for missing your guidance earlier. So the way I think about that is I've been discussing the standard, and I thought we've all been discussing the standard on the front end of the analysis, which is there a First Amendment violation? Is there an abridgment of speech? I guess I would conceptually think of strict scrutiny, narrow tailing, compelling interest as coming in at the back end to say, yes, maybe in the ordinary case, the government shouldn't have been permitted to undertake the kind of suppression of free speech that it did, but in this unique circumstance, it actually had a compelling interest, and it used narrowly tailored means to accomplish that interest. I think that's the fail-safe. If you're concerned with the breadth of our arguments, that's one fail-safe, which is no matter how broad the standard the court adopts, there's always going to be strict scrutiny at the end of the line to save the government in times where it desperately needs to do the things that you're outlining.
Thank you.
Thank you, counsel.
So what you can see from that video that while Justice Jackson and the conservative attorney general from Missouri never reach a full agreement about exactly when and how the government can encourage or even coerce or potentially censor speech, they both agree that there are limited circumstances in which the government is able to do that, and that this is the importance of the strict scrutiny standard. Now, that is when the government wants to take an action that would normally not otherwise be able to do. What they must do is go to the courts and be able to present proof that the action they are taking is one that serves a different and compelling constitutional function of government, such as national security. Then they must also demonstrate that the restriction is narrowly tailored so that it only infringes what is necessary to exercise that compelling government interest. And while Justice Jackson and the Attorney General don't entirely agree on the contours of where that would apply, the Attorney General fully recognizes the validity of applying strict scrutiny, and he even agrees with some examples of acceptable censorship that would be allowed under strict scrutiny, like reaching out to a social media company about leaked government documents that jeopardize national security. He said himself that is a place where strict scrutiny would cut in the government's favor and, censorship would be acceptable. So, what I want to do here actually is, as far as presenting how strict scrutiny works, 'cause I realize this is a foreign concept to people who maybe aren't familiar with constitutional law. And so I want to give you one example where I think we could all agree that what the government would be doing is that this action would be one that the government was justified in doing, despite the fact that they are clearly restricting speech using a strict scrutiny standard. So this is my own hypothetical. And in fact, this hypothetical is actually taken from my finished but not yet released video about the oral arguments in the Murthy case. Will be out tomorrow. So I would encourage you all to check back in then as well for my complete analysis of this case and the oral arguments. And in that video, we will be returning to my normal style of presentation, in which I am presenting the facts of the case in a holistic way that is meant to give people a comprehensive understanding of both the important facts and the key moments in a case that must be understood from all sides of the conversation to have a fully informed opinion about the nature and the scope of the case. But that said, this is how the government can, uh, I believe, for example, take action on terroristic threats. So this is the example I want to use here. So let's say someone makes a threat where they say that they are going to plant a bomb at the Super Bowl. Now, if the government establishes that what is being said is a credible threat, whether or not a bomb is actually successfully planted or detonated, simply stating that can have an incredibly negative and harmful consequence in many different ways. And for that reason, the guy who makes that threat cannot go into court and say, this trial is a violation of my free speech rights. It's not my fault they canceled the football game. It's not my fault that I caused a crowd of hundreds of thousands of people to go into a state of panic and disorder. It's not my fault that that state of disorder got many, many people hurt and cost an untold dollar amount in damages to both persons and property. It's not my fault my free speech costs these teams and the various state, local, and federal government officials millions and millions of dollars in lost revenue and in the cost of the time, men, and equipment that law enforcement required to restore order and investigate this crime. That if the people there at the game did what humans do in large crowds, and they panicked and they lost their fucking minds, all because of my bomb threat, that's too fucking bad, because all I did was engage in my constitutionally protected right to speak. Now, I ask you, does anyone believe that you have a free speech right to make a threat that will throw an entire city into panic and hysteria and cost the government millions of dollars to simply restore order and to safeguard people from that threat? I, I can't imagine anyone would disagree with me when I say that the government has a compelling state interest in preventing that kind of widespread panic and disorder. And as long as the only people whose speech is stymied is the people who are making that specific and actionable threat, a threat that is all but certain to cause mass disorder and untold harm, then yes, the government can, and I would say should, be able to prevent those people from being able to engage in that very particular act of speech. And at this point, I would be curious to get people's reactions to that hypothetical in the comment section. I know I have a lot of uh, free speech absolutists who watch my show, and I'm a free speech absolutist as well, but uh, I do see nuances like that that other people don't necessarily recognize. So I'd be curious to hear uh, if there's anybody out there who would actually argue that what I presented there, that hypothetical is not a valid example of when the government could, in a constitutionally sound manner, have acted to restrict the free speech right of the particular person making that particular threat. But with that said, um, I kind of want to close here by asking why all these conservatives are getting so angry about this comment that Justice Jackson made in regard to a purely hypothetical question that dealt entirely with persuasion through public speech, and which even the conservative attorney general of Missouri, a man who Jim Jordan supported in a 46-page amicus brief that he submitted to the court in support of the respondents in this very case, when this guy is agreeing with Justice Jackson that there are circumstances where the government can persuade, can encourage, and can even coerce speech under very specific circumstances, and where the only real disagreement between them is a matter of degree, that is to say, when can they do this and how far can they go? There is no disagreement on the factual finding that there are times where the government may restrict speech under a strict scrutiny framework. No one argues that, not on any side of this case. No one disagrees with the fact that there are times where, under a strict scrutiny framework, the government may restrict speech. And here I think we really get to the crux of why perhaps I personally find the willfully dishonest and maliciously misrepresentative tactics of hypocritical clowns like Jim Jordan so pernicious and so disgusting. Because nowadays, the only real difference between the political left and the political right and their attitude toward the court is that while the Republicans want to destroy this institution based on politically biased and selfish motives, the left clearly want to destroy this institution based on politically biased and selfish motives. Really, the only difference that I see is that on the left, they at least have the common decency to admit that that is their objective. And this is the same thing we see going on in this country. Both parties are actively trying to destroy the First Amendment. The big difference is, well, the other difference is how they're going about it. The left wants to censor speech, the right wants to compel speech, but these are both clear, absolute violations of the First Amendment. But other than that, what I was saying is that both parties are actively trying to destroy free speech. Really, again, the difference is that the left are honest about their motives, while the right are really sort of snakes in the grass here, telling you that they are the defenders of the First Amendment. They are the defenders of free speech. They are the defenders of the Supreme Court. While at the very same time, they are working just as hard to demolish all of those things. And perhaps what I find so offensive about this happening and being done to the Supreme Court is that the Supreme Court as it exists now is very, 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 very far from perfect. But they're the only part of our government not so completely corrupted by the political poison of this insane notion of the culture war that they are the only place in our government where the Constitution ever properly gets defended anymore. Now, that doesn't happen all of the time, and it doesn't even happen most of the time, but it does happen there some of the time. And that is a hell of a better track record of defending the Constitution that we have seen from Congress or from the White House in years, if not decades. Well, that is really all I have for you guys here today. Thank you so much for tuning in and checking out Legalese. If you would please take a moment and do all of those things for me that help to trigger Al Gore's rhythm. If you would, if you liked it, hit the like button. If you disliked it, hit the dislike button. I'd prefer you hit the like button, but it's your choice. You have free will. Make sure you subscribe to the channel so you always get notifications when I put new videos out. And please leave me a comment and let me know what you thought about this video. I would love to get people's thoughts about really any aspect of this video. Yeah, let me know what you thought. And again, I will have another video coming out the day after this one comes out. It will be on the full oral arguments of Murthy v. Missouri. So be looking out for that. And until next time, this has been Bob for Legalese, talking about Ketanji Brown Jackson. And of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, mother.